What's up, guys? Here we are again, another episode of Real Estate Exam Ninja. I am putting this video up from Guatemala, so I actually hope everything's okay. As all the previous videos, if you got questions or there's something I can personally do to help you pass your real estate exam, I'm more than happy to do that. If you prefer an actual test-taking scenario, check us out at realestateexamninja.com. And I'm gonna leave you with this view from Guatemala, and then we're gonna go to the questions. And that's it. Enjoy.
Number 41. The one requirement that is not technically necessary for a deed to be valid but, in most cases, is required for recordation is A. Signature of grantee. B. Consideration. C. Granting clause. D. Acknowledgement. The correct answer is D. An acknowledgement proves that the person who signs a deed, the grantor, signed it voluntarily and is, in fact, who he says he is, or who she says she is. This question may be state-specific in a few places. Consideration and a granting clause are always required, and the signature of the grantee is never required. Number 42. The type of property descriptions that use directions and distances is called A. Metes and bounds. B. Rectangular survey. C. Government survey. D. Plat map. The correct answer is A. The metes and bounds method of description uses locations, distances, and compass directions to define property boundaries. The rectangular and government survey systems, which are two names for the same thing, describe property boundaries using squares and rectangles determined by longitude and latitude. The plat map system uses a map of a property, usually a subdivision, which is filed in the local recording office. The map divides properties into blocks and lots for description purposes. Number 43. If the section you're buying is bound by Section 16 on the north, Section 22 on the east, Section 20 on the west, and Section 28 on the south, what section are you buying? A. 21. B. 15. C. 27. D. 29. The correct answer is A. If you check the rectangular survey system, township divided into sections, and are able to duplicate it, you can answer any question like this. Number 44. Elevations are measured from A. A benchmark. B. A monument. C. A meridian. D. A datum. The correct answer is D. Benchmarks and monuments are markers used by the surveyors for location and distance measurement, but a datum is specific to measuring elevation. A meridian is a feature of the government survey system and has nothing to do with elevations. Number 45. A developer wants to give the new streets in the subdivision she just built to the city. She does this by A. Dedication. B. Grant. C. Avulsion. D. Sale. The correct answer is A. Dedication it is. The government gives land to people with grants. Avulsion is the sudden loss of land by natural forces. A sale is, well, selling property to someone else. Number 46. Which of the following is not a form of involuntary alienation? A. Adverse possession. B. Avulsion. C. Grant. D. Eminent domain. The correct answer is C. The government voluntarily gives land to people with grants. The other choices are involuntary ways of losing property. Number 47. You and your brother own a campground together. You and he have very different ideas about how to run it. Neither of you wants to buy the other out, but you can no longer operate the campground together. To resolve the problem, you file a suit for A. Adverse possession. B. A grant. C. Partition. D. Prescriptive rights. The correct answer is C. Partition is a legal proceeding that divides property when the owners can't agree on how to do it themselves. Number 48. The process by which a will is processed is called A. Surrogacy. B. A trust. C. Execution. D. Probate. The correct answer is D. Probate is the way that a will is legally processed. It's done in surrogate's court, so surrogacy may have confused you. Number 49. The government is giving lands away in Alaska. It does so by A. Public sale. B. Public grant. C. Public possessory interest. D. Escheat. The correct answer is B. The key word in this question is give. The government gives property to a person in a public grant, but a sale involves the exchange of money or something of value for a piece of property. Number 50. Actual title may be granted in an adverse possession situation after a successful suit. A. For adverse possession. B. For partition. C. For quiet title. D. For prescriptive rights. The correct answer is C. A suit to quiet title is what you sue for when you claim ownership through adverse possession. A suit for partition involves co-owners who can't agree on how to divide the property they own. The other two answers sound good but are made up. Number 51. The rule that real estate contracts must be in writing is a function of A. Contract law. B. The statute of contracts. C. RESPA. D. The statute of frauds. The correct answer is D. The statute of frauds governs certain kinds of contracts, including real estate contracts, and says that contracts must be in writing to be enforceable. Contract law itself has no such requirement. Other kind of contracts can be oral. RESPA deals with closing title, and no statute of contracts exists. Number 52. As a real estate agent, you bring a buyer to a house being sold by the owner. The owner is aware that you are a real estate agent and eventually sells the house to the buyer you brought. Even though you never actually talked about it, you expect a commission because you feel you have A. An express contract. B. An implied contract. C. A unilateral contract. D. An executed contract. The correct answer is B. An implied contract occurs because of the parties' actions. An express contract clearly states what the parties agree to do or not to do, and in a unilateral contract, one party has to act only if the other party acts. An executed contract has all of its terms fulfilled. In some states, the absence of a written contract may affect your ability to collect a commission. Number 53. Joey, a 17-year-old, is big for his age. Because he wants to begin his real estate investment career, he signs a contract to buy a house a few weeks before his 18th birthday. After he turns 18, he decides he doesn't want to buy the house. He can probably get out of the contract because it is A. Void. B. Voidable. C. Implied. D. Unenforceable. The correct answer is B. The contract is voidable because Joey wasn't of legal age when he signed the contract, but he can go ahead with it if he wants to, and it is enforceable on the other person. A void contract never actually existed because it didn't meet some requirements to be valid. An implied contract exists because of the actions of the parties rather than any express agreement. An unenforceable contract is one that may appear valid but cannot be legally enforced by either party. Number 54. Which of the following is an element unique to a real estate sales contract? A. Consideration. B. Description of property. C. Legally competent parties. D. Mutual agreement. The correct answer is B. Remember that a contract, in general, requires consideration. It logically requires legally competent parties and mutual agreement about what is being promised. A real estate sales contract has all this and more. Because each piece of property is unique, a real estate sales contract would have to have the description of the property being sold to be valid. Number 55. Joe lists his house for sale at $300,000. Alice offers Joe $200,000. Joe counteroffers with $280,000. Alice offers Joe $205,000. Joe gets mad and raises his counteroffer to Alice back up to $300,000. Can he do this? A. Yes. B. No. C. Yes, but he owes a commission on the $280,000. D. Yes, but only if he counteroffers within 24 hours. The correct answer is A. As long as neither person accepts the other's offer, no valid deal exists. A person absolutely can raise his offer as long as no other offer has been accepted. Number 56. Jim finds a piece of property on which to build a shopping center. It's going to take about a year to get the necessary permits, and there's no guarantee that he'll get permission to build. Meanwhile, he doesn't want to lose the property to another buyer. His best bet is to sign A. A contract of sale. B. An option agreement. C. An easement. D. An executory contract. The correct answer is B. An option will enable Jim to get his approvals while the property cannot be sold. With an option, in the event that Jim can't get the approvals, he would not have to buy the land, whereas with a standard sales contract he would. Number 57. Harry's House of Hats can no longer pay its landlord, Jim. Nancy's House of Shoes agrees to take over the space and executes a new lease with Jim. This situation is A. A sublease. B. An assignment. C. A novation. D. A graduated lease. The correct answer is C. A novation is a new lease agreement to replace the old one. The other answers don't involve completely new leases. Number 58. A landlord does not keep a building in good repair, including not fixing a broken boiler in the middle of winter. The tenants want to move out to go to court to prove A. Constructive eviction. B. Actual eviction. C. Invalid possession. D. Lease violation. The correct answer is A. The key in this question is that the tenants want to move out rather than get the items repaired, so lease violation, on the part of the landlord, in this case, is not a good answer. In actual eviction, the landlord seeks to evict the tenant for some reason and goes to court to do it. Invalid possession is a made-up answer. Number 59. George's House of Mirrors agrees to pay its landlord a flat rental fee plus a portion of its gross sales each month. This situation is best described as A. A gross lease. B. A net lease. C. A percentage lease. D. A proprietary lease. The correct answer is C. The best answer is percentage lease because it involves some payment based on a percentage of something, usually sales in a store. This lease may be a net lease, but you would need to know if the tenant is paying building expenses as well as rent. Number 60. A person in a cooperative apartment gets what kind of lease? A. Gross lease. B. Net lease. C. Ground lease. D. Proprietary lease. The correct answer is D. The proprietary lease entitles the cooperative owner to use the apartment for which he has purchased shares in the corporation that owns the building.